Good afternoon and welcome to today's special called meeting of the Board of Registration and Elections of DeKalb County. Can we get started with a roll call?
Good afternoon, board members and members of the public. Board members, when I call your name, please respond by saying present. Vice Chair Vasu Abaraman.
Present.
Member Travis Bowden.
Here.
Member Gail Lee.
Present.
Member Dele Lohman.
Present.
Chair Carly Swift.
Present.
Madam Chair, you have a quorum.
Thank you. We are ready for public comment, so.
Public comment. Public comments may be made in person or submitted by sending an email of one page, printed less than a minimum of 12 font, to elections public comment at DeKalbCountyGA.gov, which must be received between 35 and 5 minutes before the scheduled start of the meeting. The body of your email must include your first and last name. By submitting an email for public comment, you agree to have your name and the email broadcast on the Ustream and entered into the official record and minutes of the board. The DeKalb County Board of Voter Registration and Elections reserves the right at the DeKalb Board of Registration and Elections sole discretion to either add your email to the record without reading any of it into the broadcast, or read all or portion of your email into the record in minutes. All public comments will be limited to 2 minutes. Abusive, profane, or derogatory language, holding up signs, clapping, yelling, standing, or laying in the aisles to show support for or opposition to a speaker will not be permitted. But a show of hands or quietly standing in place will be permitted to show support for or opposition to a speaker's position.
Thank you. I'm gonna call the first three names so you all know what order you're going in, and you just come up directly after the person. The first person is Cheryl Dudley. Next, we will have Bill Henderson, and after Bill Henderson, we will have Betsy Shackelford.
Hello there, Cheryl without the boot, DeKalb County resident. I really just wanted to say that since this will be my last meeting, I will not be in the country in December. Again, I'd like to thank the election board for the DeKalb election board for the work that you are doing and standing up for all people to be exercising their right to vote, which we all have. I'd also, in a way, like to thank the gentleman who's bringing these challenges today, because I was able to get in and read some of that last night. And I know what my calling will even be more for the first of the year especially is I tell people that I am a voter activist. I think that's the best that I can concentrate on. And, you know, let's spend time trying to make sure that people are, again, that we don't have the voter suppression that I keep saying that we had 50 years ago, but now it would be expanded out. And particularly with some of the things that the state election board has done. So thank you again, and everybody have a happy holiday.
Hi, Bill Henderson from Doraville. Since we're here to witness another citizen challenge to registrations that should or should not be on the DeKalb voter roll, I'd like to do a brief update on the last one that was heard here by the previous Board of Elections back in April. Back in March, I resubmitted unquestionable proof that about 134 voter registrations were, in fact, illegal under state law in Georgia. They all registered using residential addresses that were actually the addresses of post offices, UPS stores, or mail service businesses that no person could actually reside at. And for no stated reason, 3 of the election board members voted to take no action on these illegal registrations and keep them on the voter roll. So, as of the November 3rd, 2025 voter roll, I performed the same query and found that there are still 101 registrations on the DeKalb voter roll with residential addresses that are demonstrably illegal. at a recent state election board meeting, the DeKalb election office, as well as election offices from other counties, had to admit that the registrations that have residential addresses such as these should not be on the voter roll. In addition, it was stated that a new program instituted by the Secretary of State was going to prevent new registrations like these from being added to the voter roll. There are 95 illegal registrations still on the voter roll from my March 6th challenge. 45 of those are still in active status. And it looks like 6 new registrations to illegal addresses have been added since then. And 3 existing registrations were changed from probable valid residential addresses to illegal ones from October 12th to November 3rd. They were legal and they were changed to post offices. 23 of these registrations were used in 2024 to cast votes. Not sure if they had illegal addresses when they cast their votes, but that could be easily determined. Now, citizens like me get a bad name that are targets and are targets of social media campaigns when we do stuff like this.
Thank you. Your time is ended. Thank you. Thank you.
But we see this and we want answers.
Thank you.
Personally, I am adamantly opposed to citizen challenges of people's right to vote. Most of these challenges end up being invalid and a waste of the VRE's office's time and resources. Their processes may move a bit slower than some people like, but there is so little actual fraud in our elections that it doesn't make sense to waste time on these. Different note, I attended most of the meetings of the House's Blue Ribbon Committee on Elections, and my wish list for the upcoming legislative session with respect to elections is stop trying to limit absentee voting. It helps many voters. Per the Brookings Institute, data points to very low fraud and significant benefits to voters. Stop trying to limit early voting. Although some states don't have early voting, many states have 30, 40, or 48 days of early voting. If counties have to pay for all election costs, either allow them to fundraise or fund them better. At the committee hearings, I heard election office directors of small counties plead to shorten early voting because it costs them so much. Access to the vote should not be limited by county budgets. And get rid of the SEB. It hardly pays attention to its actual tasks and indulges in lots of partisan nonsense, including harassing reporters.
Okay, the next 3, Beth Ann Frillman, Terrence Parker, and Dr. Conrad Hayashi.
Very quickly, I'll just finish one point that I didn't get to make last week, and that is that individual voters really matter. I know we're just talking about processes here, and we're talking about big things, but a voter's access to the polls, whether their ballot is counted, whether their registration is processed in a timely manner, and whether their registration is protected according to the law, all matter very much. Which brings me to the point today that a change of residence is clearly covered under the National Voting Rights Act. There is a process that must be followed based on federal law, and challenges based on change of residence have to follow that federal law. Thank you.
Good evening. My name is Terrence Parker. Currently, I do not have a statement prepared or a statement necessary at this point. I'm here to address the challenge by Mr. Robert L. Asher III, quantifiable to a question of legitimacy on residency and voter registration. All right, thank you.
Good afternoon. Following the basic precepts of epidemiology and decision-making, it really makes sense to ensure decisions are made whenever possible based on data. Analysis of data from the Heritage Foundation's database. Their material may be somewhat imperfect. They admit that it's not complete. However, analysis has shown that mail-in voting fraud accounts for about 0.000043% of ballots cast. So that amounts to about 4 ballots out of every 10 million. And I've not seen any evidence when I've looked around and analyzed data for any reason that mail-in ballots, whether it be excused or non-excused, have a higher risk than those ballots that are from polling stations. And thus, data would support continuing and actually encouraging a no excuse as well as excused mail-in ballots. Indeed, it is more likely to be struck by lightning during your lifetime than it is to be able to commit mail voting fraud. About 8 states send out registration offerings to each individual who's registered to vote. These include California, Colorado, Hawaii, Nevada, Oregon, Utah, Vermont, and Washington state. In addition, there is significant cost savings when you have mail-in voting. Analysis of Colorado, looking at after their adoption since 2013, showed that there was an average of about 40% decrease in administration costs between 2008 and 2014. Thank you.
Okay, our last 3 public commenters, Dr. Kendra Bogowski, Michael Beach, and we will end, we're going to save the best for last, I think, with Teresa Mitchell.
Good afternoon, members of the board, and thank you for this public comment period. My name is Dr. Kendra Bogowski. I'm chairman of the DeKalb County Republican Party. I think Dr. Hayashi made the exact same comments at the last meeting about the absentee ballots, and I would counter that it's very difficult to analyze data when you can't even subpoena absentee ballots for analysis and have them, Anyway, moving on to my comment. First, I'd like to begin by sincerely thanking the board and staff for scheduling pre-certification meetings and making them open to the public, both in person and live streamed. These meetings are incredibly useful, not just nice to have, but essential. They give poll workers, poll watchers, election observers, and everyday voters a public forum to raise issues before certification is final. Emergencies happen. Power outages, machine malfunctions, procedural questions, or even races like Michelle Long Spears, in which significant technical and procedural problems arose affecting the outcome. A pre-certification meeting is often the only chance for those on the ground to bring those issues straight to this board, while there is still time to investigate and, if necessary, correct the record. Labeling these meetings as opportunities for misinformation, as the executive director did on November the 10th, dismisses the very real value they provide. Citizens asking legitimate questions or reporting what they saw at the polls is not misinformation. It is democracy in action. Transparency isn't a threat to election integrity, it is its foundation. The DeKalb GOP stands for transparency in data, debate, and processes. Pre-certification meetings do exactly that, and they deserve praise, not criticism. Please keep these meetings robust, public, and frequent, but not onerous, of course, to the board members. DeKalb voters expect and deserve nothing less. Thank you for your service and for hearing me today.
Thank you. We don't actually have any, we don't take any additional comment during this period, but I'm happy to discuss this after. Thank you. Thank you.
Hey, thanks. I'm Michael Beach from DeKalb County, where I'm an assistant poll manager. I just wanted to say a few words about voter challenges, and we've heard some of this brought up already today. The ones to be discussed today appear to be what we've observed in the past, small, focal, maybe personal interaction and that sort of thing. What I really want to address is how do we manage better the massive voter challenges that have occurred in the county and across the state with these Eagle AI searches with thousands of challenges that rely on inadequate public data and have lots of false positives. Ideally, the legislature would change the wording to stop this, but that appears unlikely at this time. I think we should really keep on our focus on improving ERIC, the Electronic Registration Information Center. Is there a way, to let these challengers know that a person, and thank you, Bill, for speaking earlier, because you said that you can see active versus inactive on these things, because I think we need to go back on these rules and start to analyze, are they worth it? Are they making a difference? And so let's collect some data on whether these challenges, do they catch up through ERIC eventually? Because we know we have the National Voting Rights Act and everything. But if you follow through for those 2 cycles of election, do we see that most of these are taken care of? And I think we need to know that. If they are, then we need to really start to change the wording and not have these massive ones versus just let ERIC do its job and quit trying to undermine the system that really is irreplaceable in this country. And so, thanks for that.
Teresa Mitchell. And so Teresa Mitchell is not speaking. Karen McCowan is actually going to be our last speaker. My apologies. Still saving the best for last, so come on up.
We shall see.
I mean, everyone's the best, let me just be clear.
Thank you. I'd like to make a brief comment about today's voter challenges. These 6 challenges are in a new format this time from a law firm. Although this challenge is possibly more complete than some of the previous mass challenges, I question whether it is necessary. If these voters are already tagged for removal in the ERIC system, I advocate that we let the system do its job. Thank you.
Okay. Mr. Hayashi, I see your hand raised. We do not allow any extra comment during public comment, but I'm happy to talk with you after the end of the meeting. Thank you.
My name was brought up as...
I understand. Thank you. I understand. Thank you. Thank you. Okay. We are going to move to I'm sorry. I did not ask for approval of the agenda and no one mentioned that. So we should probably approve the agenda.
Motion to approve the agenda.
Second.
Okay, all in favor? Aye. My apologies. Mr. Phillips wasn't here. He would have called me out on that normally. Okay, so today for the public's, for information, we have 2 items for decision. We have a recount certification of Decatur City Commissioner District 1 Post A, and then we have a group of challenges brought by a challenger. We are going to start with the recount certification, and for everyone's information, we will need to briefly recess in order to sign certification paperwork, and then we will move into the challenges. Okay, so I am going to ask Director Smith to provide us an overview of the recount certification. Thank you.
Thank you, Madam Chair. For your review and consideration for recertification, you will find on page 2 in your packets the incomplete and unofficial and incomplete summary report for the recount of the Decatur City Commissioner District 1 Post A contest, all tabulators and all counting groups. And I'll just inform you that there was 1 out of precinct provisional ballot, which the original duplication panel had declared to contain a blank vote for that commissioner race. The decision of the recount duplication panel was that it contained a vote for Mark Arnold. So that's the only difference.
Okay. Are there any questions? So, Ms. Lemon?
I'm just curious if, Ms. Smith, you could confirm that there were members of the both campaigns that were able to observe the processes?
So, thank you, Board Member Loban. For this race, because it was a nonpartisan race, we had requested 2 members from each city. And so there were 2 residents of the city of Decatur that the clerk recommended to serve, and they were a part of that panel.
Thank you. I don't have any more questions.
Ms. Lee?
Would you please give a brief description of the process of the recount?
Of the recount?
Yes.
Sure. It's just, the recount is just like the tabulation for a regular election. And so you have your process that contains testing, the ICCs or the scanners, and that occurred before the start of the recount on Thursday. And all of the ballots were retabulated. And so I don't know how detailed you want to go, but just as with the first general tabulation, if there were provisionals or ballots that needed adjudicating or duplicating, that occurred as well.
Thank you. No more questions.
Okay, thank you. No questions for Mr. Bowden. Mr. Abaraman? And I don't have any questions. So with that, can we get a motion to approve, to certify the recount?
So move.
Second.
Okay, all those in favor? Aye. All right, so can we get a motion to recess?
So moved.
Second.
Okay, all in favor?
Aye.
Aye.
Okay, we'll be in recess for 5 minutes and we'll be back. Thank you. We are back. Can I get a motion to come back into the meeting?
So moved.
Second.
Okay, all in favor?
Aye.
Okay, great. All right, so we have a series of challenges that have been brought by Robert L. Ash III. Is Mr. Ash present? Is his representative present? Or is a representative for him present? Hold on one second. Is the mic on? Or can we?
Do I need to press it?
Yeah.
All right. Good afternoon.
Hold on one second. Can you guys hear him?
Good afternoon.
There we go.
There it is.
Thank you.
Hello, everyone. My name is Austin Holloman. I'm an attorney at Bondurant, Mixon, and Elmore, and I am here to represent Robert L. Ash III.
Okay, thank you. Hold on one second. Are there any challenged voters present? Okay. All right. No. I'm sorry. Okay, is there a representative of a challenged voter here? Okay, great. So when we get to the voter that you represent, you are more than welcome to come up. All right. So the way that this will work, Mr. Can you repeat your name again? I apologize.
I don't. Okay. Austin Holloman.
Holloman.
Councilor Holloman. Yes.
Okay, great. So the way this will work is that we'll actually go through each challenge individually. We're going to start with Alyssa Falconer and Christopher Mann. Now, in Mr. Holloman's, right? Is that right?
That's correct.
Okay. Package, he listed the challenge voters as administratively removed, which isn't accurate. I'm going to ask Ms. Smith to talk through what happened with those voters, and then we'll move to the other four. Okay? Mike, thank you.
Thank you. With Christopher Mann and Alyssa Faulkner, they both contacted our office through mail with a cancellation request because they both moved out of the state. So those records or individuals were canceled on September 16th through that cancellation process.
Okay, great. So so there were originally 6 challenges. 2 were removed by the voter who canceled their registration, which is the standard process for being removed from the record, from the roll here in DeKalb. Okay, that leads us to the next 4. Do you have a particular order that you would like to?
So if I could, I have a presentation to walk through. I can feel the tension in the room. You can cut it with a knife.
Yeah, so what we're going to suggest,
Okay.
so the way that this works, this might be your first time at this meeting.
This is.
Okay, great. So what we do is generally the voter would provide their evidence for each voter. If you're asking,
which I have.
Okay, I see a lot of sort of commentary in here that we probably can skip through.
So my understanding of the law, and I could be wrong, is I have the burden of proof
Yep.
to successfully remove these individuals
Correct.
from the challenge. Because I respect you all as a board, what I want to do is frame the evidence that I've presented
Right, and-
in a way that's fair for all parties
Right,
involved.
and my suggestion is that you just stick to the facts related to there's a lot of sort of commentary in here.
course, yeah.
So I would suggest that
Okay.
we just stick to
This
the
is
facts
your-
around
this is
the
your meeting.
voters.
This
And
is
I-
your meeting, and I'll honor that. To
and
the
I would-
extent that it would be helpful to you.
I would suggest.
That's what I'm asking. I'm asking, would it be helpful?
I
to
would
you?
suggest that
I'm
we
listening.
stick to the facts for each voter. And so my question for you is, which order would you like to conduct? So I have in your slide 10, Jose Montanez, Margaret
Montañez.
Parker,
Yes.
Mark Toops, and Ronald Van Leek. So the
Yes.
way that we have done this is we have received information on each voter
Yes.
and voted individually because there is a representative. My suggestion,
Okay.
recommendation is that we take that process. So I'm happy to hear your context, but
Okay.
I would like it to be limited to information related to the voters.
So everything in this presentation is information related to the voters.
Sure.
It's establishing that what the burden of proof is for me as a challenger.
Slide 2 is not. Slide
So that's context for the voter challenge, because there's something I think that's important to say. And I'll just say it out loud, and I won't waste a lot of time on it.
We're wasting time now.
I'm not going to waste a lot of time on it. My name is Austin Holland. I'm a proud product of DeKalb County Schools. I graduated from Southwest DeKalb High School.
Understood.
Went to Princeton for undergrad, graduated from Howard Law School. I would not be standing before you, before this body, before my mother today if I was disenfranchising voters in DeKalb County. I would not do that.
Mr.
And so
Holloman.
I just want to clarify, if I'm able to, if I have the mic, if I can, I just want to say that this annexation, that this challenge is not related to anything having to do with voter suppression. That's not why I'm here.
Thank you. Again, I understand that is your perspective on challenges in general.
Okay.
But what we want to do today.
We can go straight to the evidence right now.
You're going to let me
Is that
speak
all right?
or no?
Yeah, no, I want to, yes, let me let you speak.
Thank you. All right, so the way that this process works is that each voter
Okay.
that is challenged, the challenger, generally the actual person challenging, would come before us and provide evidence related to that challenge.
Okay.
Once we get the evidence related to that challenge, the board has an opportunity to ask questions of the challenger. At that point, the board can take an action on that challenger or the challengers as a group. Now, generally in this context, because all the challengers appear to have the same type of information, we would take a challenge vote collectively. Because of the number, we'll go one by one. So let's start with Mr. Montañez.
Montañez, yes, Jose Montañez. Mr. Montañez, the statute requires that the election challenger meet a burden of proof to demonstrate that the challenged voter is not eligible. And we have provided this proof through OCGA 21-2-216 requires that a resident, in order to be eligible to vote, that a person, and I don't know if I have the clicker, I don't know if I'm able to use the clicker. It's here? Okay. I'm pointing it at here. It's not working. I got a laser. If you can move, if you can just move forward, if you all can move, you can move forward again. Can you go forward, slide forward? This background that I'm gonna skip. I'm gonna skip this, please, if I can go forward. One more. Because I wanna give clear to the board, I want to be clear to the board what the grounds for these challenges are. So we're going to skip forward one more. Skip forward one more. Skip forward one more. All right, there it is. Under OCGA 21-216, to be qualified to vote in the state of Georgia, you must be, and this is the part I want to focus on, 216A4, a resident of this state and of the county or the municipality in which he seeks to vote. And 216F says that no person shall remain an elector longer than such person shall retain the qualifications under which such person is registered. So that's the legal grounds for this challenge. Let's move forward if we can. One more, I think it's going to be a couple slides, I believe. So what I want to do here is, because I take these challenges very seriously, and so there's a burden of proof that we have to meet. So I'm going to tell you what evidence we're going to provide for each voter, and then I'm going to actually provide you the evidence. So the first evidence that we are going to provide is sworn affidavits signed in the presence of sworn affidavits from the current owners of these addresses. That's 1337 Sargent Avenue, 1313, 1312 Sargent Avenue, 1417 Smith, and 1382 Sargent Avenue. Sworn affidavits that the challenged voters no longer live in these addresses. Then we're going to provide deeds from the current homeowner showing that they actually own those homes. The third thing that we're going to provide is records that the individuals that we have challenged no longer live at the addresses. And in 2 instances, we're actually able to show that these individuals are registered to vote in other jurisdictions. And then finally, when it comes to Ms. Margaret Parker, to Mr. Terrence Parker, who you met earlier, will be able to testify, should you ask, as to Ms. Parker's presence, either in or not in the location. So, in keeping with the direction of Chairwoman Swift, I want to start with the evidence that we have for Mr. Jose Montañez. Can we move forward? I think it's going to be about 3 slides. So it's our overview slide. I want to move forward. So you go back one more. Yes, right there. Nope. I think back. The side is going to say grounds to strike Jose Montañez, Jr. All right. So Mr. Montañez is listed as a voter at 1312 Sargent Avenue Southeast. But you will see here we've actually produced the deed that states that Mr. Montañez sold his home to Christopher Mann on June the 26th, 2020. Now, again, we have a burden of proof to make. And I want to be clear to this board, we're going to meet that burden of proof. And we have been able to find through research that Mr. Montañez currently lives in Hope Mills, North Carolina. And it's small, but you can see actually on this presentation, we have, and it's in the packet before you, we have found that Mr. Montañez has voted in North Carolina in both the 2022 midterm elections and the 2024 general elections. I'm not sure how you all would like to go through all of the evidence, because I also have the evidence of the current owners of 1312 Sargent Avenue. So should I skip forward to show you that, or?
No, I think we can read it in the packet.
Okay, okay.
Is it the same type of, just so we're clear, these are all challenges based on change of address?
Not change of address. It's that we have evidence that these individuals no longer live at the address under
Correct,
which
so
they're
their
listed.
address has changed, meaning they are no longer, your challenge is that their address that they are registered is not the address that they live in now. That's
No, ma'am. It's that they don't live there anymore. And if you go back
Okay.
to the statute, 216,
Thank you. I understand.
Okay.
It's a change of address. Okay. For that, got it.
well, I think it's a distinction. It's not a change of address. We're not alleging that these people changed their addresses and are no longer eligible to vote. We are alleging that they are not residents of DeKalb County.
Yes.
And because of their non-residency, that they are not eligible to vote because they are not residents of DeKalb County.
Thank you. They're no longer eligible to vote. And according to you, there's a change of address that makes them ineligible to vote in DeKalb. Okay. Let me just ask the board, do we need more information on these specific challenges now, or do we want to start to ask questions? Because it appears, or do we want to go through the evidence for each one of these? Can I just get a poll? Ms. Lohman?
Thank you, Madam Chair. I have immediate questions. I imagine that they will apply to the entire group. And so I would suggest that maybe we get an overview of what the argument and evidence is for each of them ahead of it, and then we can ask questions from there.
Okay. So we have Mr. Montañez. We have let's just go through.
They're in order in the presentation. All right, so that's the evidence for Mr. Montañez, if I can get my click. And I wish it could work, but it's not. I think it went 2 slides forward. I think the next.
Is it slide number?
Slide 12, I believe, should be, this is.
Yeah, slide number 12.
This is Margaret Parker, it should be next. I think it went too far forward. We're too far forward on the presentation. Margaret Parker, yes. So based on the evidence that we have so far, and again, this is a situation where Mr. Parker is here. If you have questions, I think he will be able to testify. He is a blood relative of Mrs. Parker. But based on the evidence that we've been able to find, Ms. Parker never lived at 1337 Sargent Avenue. We've been able to locate her in Alexander City, Alabama. And again, as for Ms. Parker, this is a challenge that is based on non-residency. So that's Ms. Parker. If we can move forward on the presentation. I believe our next voter is Mark Toops. All right, that's wonderful. So, Mr. Toops is now a homeowner in Belle Chase, Louisiana. There was a time where he did live at 1382 Sargent Avenue. But Mr. Toops, much like our first challenger, is currently a registered voter in Louisiana. So we found his voter records. Those voting records are actually in your file. And our petition is just that you would consider that Mr. Toops is not a board member, is not a resident of DeKalb County and has not been for some time. And we have additional documents that we didn't feel needed to be presented in this public hearing in your packet. I'm gonna move forward to the last challenge. It's the grounds to strike Ronald Leaks, who is listed as a resident of 1417 Smith Avenue. Mr. Leaks sold this property in 2021. We have evidence that Mr. Leaks now lives in Pavo, Georgia. The extremely long 76-page document that is only on the board's files are actually all of the information that we found about Mr. Leaks. And again, for us, it's just clear that Mr. Leaks is not a resident of DeKalb County as he's required to be under the law. So this is what we have found. But we also have evidence presented, if I can get my next slide, from the current homeowners of these addresses who swore under oath and in the presence of a notary that they are the owners and occupants of these properties and that no other individuals live in either 1337 Sargent Avenue, 1312, 1382, or 1417 Smith Avenue, Southeast. And in your packet and on this slide are the sworn affidavits of Max Hostetter, Adam Cohen, and if we move forward to the next slide, you'll see the final affidavits of, actually, I think we went too far, but Terrence Parker and Dylan Vollrath, that these individuals and these individuals alone are residents of these properties.
Okay, great. Thank you for that presentation. I'm going to start with Ms. Lohman.
Thank you, Mr.
Ms.
Holloman. I actually would like to ask a couple questions of our executive director and attorney first. Ms. Smith, could you advise what the process was that the department took upon receipt of these challenges?
Yes. So when we received the notification of the challenges, staff did research on each of the challenged voters and updated a spreadsheet for our records. They then mailed notices to the individuals to inform them of the hearing date. And so those notices are mailed regular mail and certified mail, and we receive generally if there's someone there to receive the mail, we receive there's a green card that comes back, and a lot of times it's signed by either the individual that it's addressed to or someone that's at that location And so we update the records accordingly. And there are also times where an individual will call and let us know that either they've moved or that they are still there, and they'll update, the information at that time. When we receive returned mail that is noted in our system, and the voters will be added to this clock that is 30 days or 40 days, which they become inactive if their record is not updated as it should, to remain active. And so after they're made inactive, of course, there are different ways where they can become active again, but if they don't have contact with their office or vote in a general election for 2 cycles, then the state's process is that they are canceled after those 2 general election cycles.
Thank you. And did the 2 individuals that were listed, Alyssa Falconer and Christopher Mann, ask to be removed in response to correspondence, or that was a separate?
It's my understanding that we received the challenges after the individuals had contacted our office directly to be removed.
Thank you. And one more question, one more. Do we have any way of knowing if these individuals received contact during the recent, the Secretary of State's recent efforts? I'm forgetting the language, but you know what I'm talking about.
List maintenance.
Thank you.
Yes. And we would know that because if we received something back, their information would have been updated.
Okay. All right. Thank you. So to our attorneys, with the acknowledgement that you may have wished to take more time to respond to this, I am curious how the request that is before us aligns with both the process of list maintenance that the Secretary of State undertakes, as well as the National Voting Rights Act and the requirements within.
So I'm going to try to answer your question. I think what you're referring to is the National Voter Registration Act.
That's what I meant, yes.
Which sort of limits the ways and the reasons that you can remove, that states and counties can remove voters from the registration rolls. And that limits it to things like the death of the voter, incapacity, written, when it comes to evidence of change of residency, NVRA says that you have to either then have written confirmation from the voter that they've moved, or then you have to go through this contact and 2-year cycle process, which is what I think you're referring to the Secretary of State was doing. So does that answer your question?
It answers my question exactly and very succinctly. Thank you. So I think that we know that when there is a discrepancy between state law and federal law, at least with regard to elections, that federal law takes precedence. And so, as our attorney just stated, there are specific requirements under the National Voter Registration Act for why someone can be removed from the rolls outside of the process that is outlined in law. And so my question to you is, how did you or the challenger, Mr. Ash, come to be aware of these particular individuals and the fact that they may or may not live at the addresses where they're registered?
Absolutely. I think that's a wonderful question. So, and I didn't get to talk about this in the beginning, but democracy is at work within this challenge. These individuals, if you'll notice, all live in an address that is within They all live on either Sargent Avenue or Smith Street. And that is because the voters in that area have filed a petition to annex into the city of Atlanta. So you have almost 180 voters who are under a statute that I didn't want to, I wasn't, or I think in deference to the chairwoman, I didn't want to talk about. But these 180 voters have stated they want to be residents of the city of Atlanta. And so to complete that process, you must evaluate, you must get signatures of the total registered voters. That is required by the statute. I wanted to walk through that, but I won't do it. It's in your packet. Because these individuals are currently listed as residents and do not live there, it is more difficult for these individuals to actually do as they wish to do, which is move from as citizens of unincorporated DeKalb County into the city of Atlanta. And so we are here to defend the rights of those 180 people, not to challenge these voters unfairly. But that's how we came to know that they don't live there, because we have petitioners who are trying to become citizens of Atlanta who have had a harder time doing so because the voter rolls are inaccurate. And so we're just trying to get it right.
Okay, so am I to understand that your firm is involved in the annexation process?
We are, yes. I'll be transparent about that. I wanted to be transparent about that, yes. We represent, as my day job, I represent the city of Atlanta. I represent the city of Atlanta in court, and in this petition, I'm representing Robbie Ash, who is an attorney for the city of Atlanta. So I felt like it was deceptive to not say that up front. I was told that would be a distraction, so I didn't want to. I wanted to honor the chairwoman's wishes. And so, but full transparency, yes, that's why we're here. And that's why we've invested the resources, and that's why, as we see it, we have followed state and federal law, because the federal law does not say that a voter cannot be removed for a valid state grounds. The federal law is talking about purges of voter rolls. And we don't believe in that, we reject that, and this is not a voter purge. And you see from the evidence that that's not what we're doing.
Okay, so I would like to ask the attorney again if you could respond to the supposition that Mr. Holloman made, that this request somehow does not run afoul of NVRA.
So there are a number of different provisions in the NVRA, right? And one of them talks about mass voter purges and systematic challenges. This is not what we have here, but it still speaks to individual challenges too, about when there is evidence of a change of residence, which is what we spoke about, which I mentioned before.
Okay, so would it be correct for me to conclude that this actually is not an exception that is allowed specifically in NVRA?
I think that's right.
Okay, thank you. I'm going to stop here, Madam Chair. I'd like to hear from the gentleman that also came, but I'd like to defer to my colleagues if they happen to have any more questions.
Let's just get the board to get their opportunity to ask questions, then we can, if the board would like to hear from any of the other representatives present, we can. So Ms. Lee.
I would like to hear from the representative, the witness for Ms. Parker. Excuse me.
Okay, we're gonna do that after we get this round of comments, and then Mr. Parker, we'll have you come up, okay? Mr. Bowden.
So I asked, could you just walk me through the process as it's described with the Voting Act, the prescription for how this changes in relation to the annexation. I understand that you're representing the city on this matter, and you're dealing with the people that are trying to become part of the city of Atlanta. But
Right.
and I apologize for phrasing it this way, but could you get a little more granular on that, just for my greater understanding?
Yeah, look, I think that's the key question that I think this board is grappling with, and I think you guys are doing it in good faith, and it's a good question. Our position, and if I can get you to go back on the slides a little bit, is that the National Voter Registration Act is not our challenge, and I quibbled with Chairwoman Swift earlier, but our challenge is a state law challenge. And states are allowed under the National Voter Registration Act to establish qualifications for voting. They can't be unconstitutional. You can't have an unconstitutional grounds for being eligible to vote, but you can have a residency requirement. And so if we can keep going back to, go back one, I think 2 more slides. Okay, actually, you're gonna go forward from there, I'm sorry. So, yeah, 1, 2, one more. One more. Actually, it's gonna be another one. Another one. And I think this is this next one more. All right, yes. So what the state of Georgia has done is, in accordance with federal law, is stated that there are residency requirements to be qualified to vote in the state of Georgia. So this is not a purge that we're engaged in. We're not engaged in a purge. We are engaged in a challenge to these qualifications under state law. And the National Voter Registration Act does not state that there are no qualifications that a state may impose. And so our position is that the governing statute in this case is 216A4 and F, and that under those provisions, that you guys are not running afoul of the federal law at all in actually voting to strike these individuals as unqualified.
Madam Chair, may I make a brief follow-up question?
Yes.
It'll be brief. It does not appear to me that you are conducting a purge, because it appears to me that you have documentation here that these individuals that are listed as living in these addresses do not live in these addresses.
That's correct.
I guess my question is, in a more macro sense, if there was to be a harm that would be caused by, theoretically, from your perspective, if this change were to occur, who would be the...
I just want to clarify which change. If you said this change.
Well, I mean, we're talking about people being represented as living in an address, right?
Right.
They're not living there. I mean, and a clarification, it appears to me, is being sought. I mean,
Yes, that's what we're doing. We're seeking
that's fair to say.
Yeah.
From your perspective and the research you've done on this, and I see that you and your team have done a great amount of research on this.
Yeah.
Who would be the individuals that would find fault with this, apart from those saying that the federal statute would take precedent over the state statute? You see where I'm coming from on that?
I do, and look, I really am not here to fight a political fight. I'm just not. I'm a lawyer by training, again, a proud graduate of Howard University School of Law, where our training required us to follow the law. And so that's my position is, I have set before you what the Georgia law requires. The federal statute does not govern in this case because the federal government gives states the right to establish qualifications.
You've sold me. You're not fighting with me. I just was curious, because you've researched it a great amount, and I find it usually helps to ask an expert when I'm trying to learn these matters. Thank you.
Thank you.
Mr. Abaraman?
Thank you. Can you talk about the annexation effort and
Absolutely.
how these challenges are materially affecting it?
Yeah, if I can go back a little bit. The very first, that's the details. I think it's going to be 2 slides from here. One more slide. And thank you. Look, everybody, this is democracy in action. And it's uncomfortable sometimes, it's hard, but this is actually, on this slide, is the annexation petition. It's from Lexi Martin, and it was sent to the City of Atlanta on October 7th of this year. And it's just citizens of unincorporated DeKalb County, and I'm partial to unincorporated DeKalb County. I was born and raised in unincorporated DeKalb County. It's just citizens of DeKalb County saying, we want to join the City of Atlanta. And the General Assembly provides a method for citizens of an unincorporated county to join a municipality, as is happening in this case, under what we call colloquially the annexation statute. And so that requires citizens of a particular jurisdiction to get both 60% of the landowners, that means you have to get people who own land, and 60% of the registered electors. Now, that's a complicated, that's a mouthful term that just means the registered voters. And so that's what's happening in this case. And if you go to the next slide, I'll give you the details of this annexation and where it stands at this point. So the annexation is this community that is right off Boulder Crest Road on the east side. It's a 50-acre territory that has currently met the acreage requirement because 33 of the acres, 33 and a half of the acres of the people who own that land have said, we want to join the City of Atlanta. I think I told you 179 earlier. I think I got my numbers wrong. Total number of electors is 176. So it's 176 registered voters who live in this area. And so far, 119 of them have said, yes, we want to join the City of Atlanta. Now, 57 of them have not signed the petition. So we've categorized those individuals as no's. These are people who have not stated affirmatively that they want to join the City of Atlanta. 60% is the threshold. And what we're aware of is as these things move forward, people change their minds, we want to get to the 60% threshold. And to do that, again, we want to have as clean a voter roll as possible. And so this petition only exists to have the voter roll as clean as possible so that the 119 total electors will be in the 57 no's. Right now, those 57 no's include Alyssa Falconer and Christopher Mann and Margaret Parker. And so it makes it—
Sorry to interrupt, as affirmative no's?
Yes, they're no's. That's how the statute works, is that if you don't sign, you're a no.
Sorry.
So
not an affirmative no, just a constructive
they're not,
no.
Yeah, they're
okay.
As far as in terms of the annexation, they don't count as people who have said yes.
I get it. I wanted to know if they
because
had
this is one of those, if you're silent,
you're
silent, it's a no.
I get it.
So I know you understand. So again, our goal is to make it more likely that we get this petition complete, and that's why we're bringing this challenge. Any other questions?
Do you have questions?
Yeah,
Okay.
I do.
Yeah.
Well, first, I wanted to give our attorneys an opportunity to add any nuance to what Mr. Holloman has presented about annexation based on any of your own research or knowledge here.
I don't know that there's anything we really would have to add in the annexation process. We're aware of this one happening. I think the one thing I would add about the NVRA, if I could go back to that since I have been asked about it, it is true that under state law there are qualifications for determining eligibility to vote. The NVRA discusses how to remove them. It's the process. And so there's an interaction between the state law and the requirements for determining eligibility and how you actually go about removing somebody in the NVRA.
I wanted to ask our department, I know some of these voters, the challenger through representation is saying that they live in another state now, or that they've changed their residence to another state, their legal residence. Have you heard from the government of another state in this process?
No, we have not.
Okay. Couple more questions. The voters that are left being challenged here, have you spoken with any of these voters about where they consider their legal residence to be?
So I think you'll get the best discussion from Mr. Parker on where Mr. Parker considers his legal residence. We have where Mrs. Parker considers her legal residence. So that you'll have the chance to ask. What I'm saying is you'll have a chance to ask Mr. Parker about Ms. Parker.
Okay, about the other ones.
For the other voters, we have, as you've seen, we've done due diligence. We've searched.
I get it. Very specific question. Have you heard from these voters directly about where they consider their legal residence to be?
So we have.
No, I understand how you want this process to come out, and there's a way to answer this question to present that evidence. Right. But I'm just asking a very narrowly tailored question here. Have you heard from these voters?
We have not spoken on the phone with these voters, if that's your question.
Emailed?
We have not
Okay.
had.
You have not heard from these voters through any channel of communication?
No.
Okay.
No.
Would it be accurate to say that you have no personal knowledge of any of these voters' intents regarding their legal residence or domicile?
So intent can be inferred from the fact that they've sold the homes and purchased new homes. We've tried to provide that evidence.
You know what I mean when I'm saying the term personal knowledge, though.
Yeah, but no, I have the evidence that I've presented.
Yeah, I just wanted to make sure.
No,
right?
I understand, yeah.
Do you agree that domicile or legal residence requires knowledge of the voter's subjective intent and not speculation?
So I think I know what you're referring to. And domicile, in this instance, in the instance that you're referring to, is speaking about someone who moves away from the state with an intent to return. You can think of college students who go off to college and have an intent to return. Here, I don't think that applies because we have evidence that these homes were sold. We have new home purchases, and I think at least in 2 instances, we have voter registrations in other jurisdictions. And so the intent question that you're asking isn't relevant because these individuals have demonstrated. And you should note on that question, because the legal question you're asking is, do you have intent for the voters? And I'll just say this, if you have registered to vote in another jurisdiction, that is intent to live in that jurisdiction legally. There's a different question for those who we don't have that for. But for those who have registered to vote in another jurisdiction, that suffices as intent to leave.
I agree with that statement. I'll go on the record saying that. You familiar with UOCAVA?
No, I'm not.
Okay. Are you aware that in the fall of 2023, we did not sustain voter challenges based on the possibility that these voters were still eligible under UOCAVA, even though their homes had been sold?
So I was concerned about that coming into today. I don't think I knew the doctrine, or I don't think I knew the example that you referenced, UOCAVA, but I was concerned that the possibility that these individuals may return to DeKalb County would weigh on the board's heart. And look, I'll be honest, it's something that we thought about too. you're going to guess where my answer goes, is that in this instance, because they have fully departed from the qualifications, and in the instances where these individuals have registered to vote in other jurisdictions, we just think that the factual comparison between that instance and these is just different.
I hear you.
Yeah.
Do you have something that may qualify as an official communication from a different state that one of these challenged voters is registered there? And I mean super official. What do you got?
So the evidence that you're asking for is, do I have a letter? I don't have a letter from the state of Louisiana. I don't have a letter from the state of North Carolina that Jose Montañez is registered to vote. I have his public voting records and that he has registered to vote and has voted in North Carolina. And I have the same thing for Mark Toops, and Mark Toops has registered to vote in Belle Chase, Louisiana. And
Yeah.
that's what we have.
Explain how you have his public voting records.
Though they're often public. In this instance, in Georgia, if you have a name, a date of birth, we actually.
What did you do to have them?
Yeah, we searched. So we actually, our team has an investigator. And so all of the evidence that you've seen is a result of a sworn, certified investigator who found these individuals, found their homes, and we invested the resources to ensure, because I'm just going to speak for our firm, the standard for us is that we would not do this if we were not 100% confident that these individuals are not eligible voters, because we believe that to disenfranchise anyone is to visit upon them the worst of all acts. We believe that fervently. And so again, I stand before you today confident that these individuals do not intend to return under any definition of the word intent. I stand before you today because I am confident that at the core of my being that these individuals have left Georgia and have no intent to return to DeKalb County to vote.
So let's say in a situation where someone's registered in Louisiana, right? And we hear from the voter, okay? We hear from the voter themselves.
Okay.
That they've intended to change their legal residence to Louisiana.
Yeah.
We also have an official communication from the state of Louisiana saying that they registered to vote there.
Okay.
You just said you're 100% sure about these voters.
We are, yes.
So you would say that the evidence I just described should be viewed as immaterial to us in any of these challenge situations because what you've already presented gets to the 100% threshold?
I'm telling you that I'm 100% confident. I recognize your job is to evaluate whether we have met our burden of proof. And so I understand and respect your questions and doubts. We have found, in the case of Mark Toops, there's an article that I provided for you in that packet. I think it's document number 18 or 19 that I think is unequivocal evidence that Mark Toops is in Belle Chase, Louisiana. And so, again, we are certain that these individuals have left Georgia with no intent to return. And so although I respect your question, and I think it's applicable in a different case, here, we don't think it applies.
I understand. If I'm asking about personal knowledge of these voters' situation, do you acknowledge that you're only really presenting evidence of personal knowledge based on one of the voters who remains challenged?
So as an attorney, my job is not to present or to even find personal knowledge, right? My job is to present evidence of these individuals are listed to vote in the areas that they're listed. I have personal knowledge of the people who live at their homes that these individuals are not there. But we did not stop there. We could have stopped there. We could have stopped at, hey, we know that these addresses, these individuals don't live here. We went and found them because we care, because it matters to us. And we are confident that we found them in places that demonstrate that they are no longer qualified voters because they're no longer residents in DeKalb County. And to the extent that there is concern that they may have an intent to return, their purchase of homesteads and their registering to vote in those other jurisdictions, we think clears that question.
I do appreciate that in response to my questions, as a talented attorney, you're trying to represent the whole corpus of evidence. But I guess I'll ask it again.
I want to ask you a question. Yeah, help me answer your question. What's the question?
Yes, that's right.
Yeah.
In terms of anybody here who has personal knowledge of any of the remaining voters who are being challenged, their situations, you just have evidence about one of them.
So, no, not at all. Your question is, what personal knowledge do we have? Do I understand your question? What personal knowledge can I give to you?
Personal knowledge of the voters' situation themselves.
So you want someone to testify that these individuals live in another jurisdiction without the intent to return?
Yeah.
I'm just trying to understand
Sure.
what you're asking for.
Yes.
So on that question, no. And in some ways, it's very hard to prove a negative. We have, as far as we're concerned, we believe we've met the burden of proof to show they're no longer qualified. But we do not have individuals who can testify that they left without the intent to return. We have individuals who can testify that they have left and that they don't live at their current addresses.
Mm-hmm.
So that's the personal knowledge that we have. We don't have knowledge that they never intend to return to DeKalb County. But I just want to warn you, if they did, they would be eligible to register to vote.
Yeah, for sure. And you probably could tell that some of my questions are about speaking to the evidence that the residence has changed.
Yeah.
As in a new legal residence has been established.
Yeah. And on that question, we have deeds, we have home purchases. On that question of has this residency changed, we feel, not only do we feel confident, the evidence is before you, that these individuals have purchased homes, they live in different jurisdictions, and that they're no longer residents of DeKalb County.
Yeah. I'll make a comment here.
Can I ask a few questions and we'll come back around?
Yeah.
And we can save your comment. Okay. Ms. Holloman, quick questions. These are questions that I generally ask for all challengers, so you've probably answered them.
Okay.
Are you the challenger?
No, I'm counsel for a challenger.
Great. Do you have any actual knowledge of any of the voters do you have any actual knowledge or do you have any personal knowledge of the status of the 4 remaining voters that are being challenged?
I have the knowledge the evidence that I've presented before you today is what I have.
So do you have any personal knowledge? Simple question.
I don't know these individuals personally.
Thank you. Okay, now, are these new challenges? Do you know if these challenges have been presented before?
These challenges have not been presented
To your
before,
knowledge.
to my knowledge.
Okay, great. So let me ask, I have a question for, I think it's for our legal team. With respect to the National Voter Registration Act, does change of residency requirements in the National Voter Registration Act preempt any state law requirements related to the elector?
As Ms. Lohman said, federal law controls if there's a conflict over state law.
And would the requirements for list maintenance under the National Voter Registration Act, if they related to change of residency, override a state law qualification? So,
yes.
Okay, all right. So, and sorry, one more question. In that instance, how does the active versus inactive status of a voter in Georgia relate to the list maintenance requirements under the National Voter Registration Act, or do they?
So that is the process that's required by the NVRA, which has started in these cases. My understanding for these 4, they are now on the clock. So if they don't respond within the 30 days, then they will be put on inactive. And so under state law and the NVRA, if they're inactive for 2 federal cycles and they remain inactive, in other words, they don't vote during those 2 things, then they'll be removed from the list.
Okay, and this is for the office, Ms. Smith. Where are the 4 remaining voters? What status are they, and where are they in any process?
So out of the 4 remaining, 1 is in inactive status due to no contact. And
Who is that?
the one that's inactive is Jose.
Okay.
And then we have 3 who are inactive status, 2 of whom are on the clock and have about 15 days before moving to inactive.
sorry.
And that,
Can I request that the word inactive and inactive
Oh,
be very
yes.
clearly?
is it my accent?
Sorry, this is a little.
Sure, yes.
So they are in. So there
They
are
are
3 people in active
In,
status.
there, they are active.
Okay.
And 2 will become inactive in 15 or 16 days. And then the 3rd one, I believe, is the Parker is active.
Okay, so
Is active.
if they're in active status, that means that they have responded to a mailer.
Yes, well, the one that is active recently updated their address.
Okay. So who is that?
That's Margaret Parker,
Okay.
and that's this address that's being challenged.
Okay. And when was that update made?
August 5th,
What year?
2025.
Okay. Thank you. And then so that leaves Mark Toops and Ronald Van Leeks, who will go inactive in 15 days.
That's correct, if there's no contact.
Okay. So, Counselor, you're familiar with preemption.
I am.
Okay. And your argument here is that the National Voter Registration Act, which provides the requirements for list maintenance, does not, hold on, I'm gonna finish, because you like to cut me off. Give me a second here, sir. Come on up. So, no, you can come stand at the podium. I wouldn't want to. Okay. Just want to be clear about that. So, we agree, federal law preempts state law generally. And you made an argument, a case that you believe that the National Voter Registration Act does not, or that there's an exception for the Georgia qualification requirements under residency.
Are you asking if I agree with that
yeah.
statement? I don't agree with that statement.
Okay, great. Tell me, give me a brief answer for why you don't.
So I'm in the statute right now. That's
I
15.
have the statute.
Okay, 15 USC 503. You say that the law preempts. Can I get the Georgia qualifications slide? That's going to be 2 slides, I think, from where we are right now. That's perfect. All right. In Georgia, no person shall vote in any primary or election held in this state unless such person shall be, and in the legal field, we like to skip around, but you must be a registered elector. You must be a citizen of this state and of the United States. You must at least be 18 years of age on or before the date of the primary election. You must be a resident of this state and of the county and the municipality in which he or she seeks to vote. And you must possess all of the other qualifications prescribed by law. So there is nothing that I have seen in the National Voter Registration Act that says that if you don't meet one of those 5 qualifications, that you still have the right to vote. And so to the extent that you can help me.
Yeah, we're, okay. So are you familiar with active versus inactive status in the state of Georgia?
I am.
Okay, so we agree. Help me understand. What is your understanding of active versus inactive status?
Active voters are voters with whom contact, I believe, has been made within the last two election cycles, and then if that doesn't happen, you become inactive. Is that correct? Is that your understanding?
Is that generally? No. Okay. Mr. Abraman, do you want to?
Yeah,
provide some
I'd probably
additional
defer
insight?
to our attorneys here,
Yeah.
but to become inactive, it's one of the ways is not voting. It's a much longer period than that. And then
Yeah.
there's the NCOA list and return mail. If you could talk a little bit about that.
Yeah.
I mean, I think the main way is not responding to certain mailings that are sent out.
Yeah. I think the challenge that we're having is, and I understand you're zealously representing your client, and so you're focused on the Georgia statute, but you seem to have not included NVRA. You don't seem to understand your CAVA, and you don't.
I'd love to know
you don't.
where an
Okay,
NVRA
give me a second.
Okay.
And you're missing some of the other federal laws. But before we get there, let me just. Would you agree that the National Voter Registration Act provides the requirements for list maintenance? Are you familiar with list maintenance?
I understand list maintenance.
Okay.
Our whole point is that this is not a list maintenance request.
I understand that is your point, but I'm asking if the NVRA provides the framework for list maintenance.
I can't say.
Okay, I'll ask our lawyers. Does the NVRA provide the framework for list maintenance?
It certainly provides restrictions and guidelines on how that is to be conducted.
Okay, and when there is a change of residency, are there requirements around how a state, a municipality, a county can remove an elector?
There are, and I would just sort of back up when we're talking about preemption. Before federal law preempts state law, you try to read it together so that it interacts and is not violated. So I think that's what we're talking about, how the NVRA interacts with the state law, not necessarily preempts it.
Right, and in this instance, where, I guess, Mr. Holloman, would you agree that each one of these voters, when they register, whether or not we agree they've removed or whatever, when they registered, they were DeKalb County electors?
No, not all of them, no.
Okay, so you don't believe any of them registered
No,
as
that's
DeKalb
not what I
County
said. I
residents?
said not all of them, no.
Interesting, okay.
Would you like to know which ones?
Sure, I'd be curious to see what you believe those.
Yeah, so
those-
again, this is not what we believe. Our research has shown that there's a question about whether Margaret Parker ever lived at the address. And again, Mr. Parker's here, so he can testify to that. But our question is, Margaret Parker, all others, yes. Everyone else, the other 4 people, at one point were eligible voters in DeKalb County. We don't contest that. We contest, except for Margaret Parker, where we haven't seen evidence that she ever lived.
Again, okay, based on okay. So, but let's just go back to, so all of the electors, we agree, were properly registered in DeKalb County when they registered, right? So then if they moved, it would be a change in their address, if they moved, right? If they no longer are residing at the property where they registered, where we all agreed they were valid electors. So when they moved or left the county, their address changed.
If they became no longer residents, then that's different.
That's not the question, because we're talking about the nuance. So when
that's a big nuance.
they were,
You can
hold on.
change it? Okay.
They lived at 123 Smith Street when they registered, which was a valid
Yeah.
DeKalb County, they were a valid voter.
Ronald Van Lee.
When, at some point, according to your belief, evidence, whatever, they moved.
We have affidavits.
Yeah, sure. They moved. Now, lawyers, legal team. When a valid elector changes their address, does that implicate the NVRA?
Yes.
Okay.
Not all the time. That's incorrect. Not all the time.
Hold on.
Not all the time.
Hold
Not
on,
if you
Mr.
change
Holloman.
residencies.
Mr. Holloman, I'm
I
going
have
to
to
ask
make that
our legal team, who spend the majority of their time on voting issues,
I understand.
which is clear here. So I just want to go back to my question. If an elector was registered as a valid elector in an address in DeKalb County, and their address or residency changes, does that implicate the NVRA?
Yes.
And what is the process when we look at that in tandem with Georgia law for removing the voter from the rolls?
Well, So it depends, because if there's written confirmation by the voter, that can count and it can be removed then, right? But if there's not written confirmation, then we start going through this 2-cycle process that we've discussed.
Okay. And just for the record, we're clear that the 4 voters that are being challenged, one is currently in the inactive process, so they've at least voted. Can you remind me, where are they in that status? Oh, you need your mic.
The individual who is inactive has never voted, so there's been no contact.
Okay. And so they've had 1 cycle. They're about to be in their 2nd cycle. The other 2 are about to go into inactive status in 15 days, which will put them in the process. And the 3rd one had an update to their registration.
Yes.
Okay. I actually have a lot of sympathy for you and your annexation. I live in Atlanta in DeKalb County. It's unfortunate that, this is happening, but we here are tasked with making sure that we follow both the process and have the ability for people to vote. So I sympathize with that. I actually don't have any more questions.
Thank you.
Thank you. So what we will do is we will have Mr. Parker come up, and we're gonna just ask you some questions, and then we'll see if we have another round. All right, thank you, Ms. Lohman.
Oh, do you have a statement, maybe? I can respond to your statement.
I do.
Okay.
First of all, the councilman answered my question initially when I received documentation at the end of September to my address, addressed to my mother. That is the resident that is in question. She isn't the resident, the person that's in question. He answered that question because I asked him simply when I had first opportunity to speak with him, what is this coming from? And all that being said, I have been a DeKalb resident since August of 2005. I purchased a home in the city of Atlanta, unincorporated DeKalb County. I currently reside there. There's never been a break in time during my occupancy. My mother has never lived with me. She no longer lives in the state of Georgia. She retired upon retirement approximately 3 years ago. She made the decision to move back to our home state of Alabama. Her final residency in Georgia was in Henry County. She has never resided, rented in DeKalb County. She's never sought to move from her residency to live with me. There is a vehicle registered in her name, but it is to my address. I currently occupy the vehicle. That's it. I've never rented the home to anyone else. She's never sought to live with me. So upon her decision to move, she did not choose to move with me. She moved back to Alabama. And so that's where she resides permanently, primarily. She works there. And that is all that can be stated on that, and perhaps that's clear enough. There was a date reference by the Executive Director Smith. Upon receiving the correspondence, I called and had the conversation with her to get some explanation and clarity on I called the office. Okay, your staff. About what it was about, basically. And so from that perspective, my mother did have a conversation, because I had her to call in as well, to say, no, I do not live in Georgia. Even when I lived in Georgia, I did not live in DeKalb County. I live in Alabama. The street address to the residency in Alabama is a family-owned property. Councilman displayed what their research found, which is accurate. The names listed on the property, which is my mother, and my aunt's name is on it because it was inherited through their mother. So it's a family property. So when she moved from Georgia, she went home, literally. And that's where she resides. She visits, but she doesn't live with me and never has. And as far as voting goes, she's made it very clear to me, and that's where the personal aspect comes in, that there are currently no plans for her to move back to the state of Georgia. And there's no attempt for her to seek to utilize her voter rights through absentee voting while living primarily in Alabama. She has nothing that she wants to do with the state of Georgia in that regard, and she never has had any intention of voting in DeKalb.
Okay, thank you. That was unexpected.
That's why I'm here, because it's a lot more that can be ascertained rather than the documentation train.
Okay. So I am going to resist all of the sort of tendencies that have been nurtured in me by watching years and years of mysteries and just cut to the chase and ask if your mother does not intend and believes that she should not be registered to vote in DeKalb County or even in Georgia, if she can follow the process that the other two individuals did and contact our office to officially cancel her registration.
Not a problem.
Okay.
And I have all of the documentation that I received at my address, mailed to her name, but to my address. So the most recent one I believe I received late last week or early this, well, yeah, it would have been late last week, in regards to a voter registration form. It is incomplete because she has no intention, and she's not even present to sign. So I definitely would not have sought to complete any form if she had an intention, but she has no intention. And so I just brought the form along with the other documentation, which is blank. You can see it if you need to. So it's blank, it's in my possession. It will not be submitted forward as an opportunity to become a registered voter in DeKalb County or the state of Georgia in totality.
Okay.
So if she needs to formalize in an email or a letter, that's not a problem. I know her current voter status in Alabama. So with all of those facts, there should not be any reason why it can't be clarified for you all that she's never lived in DeKalb. She no longer lives in the state of Georgia. She has no current intention of returning to the state, and definitely not voting absentee.
Okay. Thank you. Yeah,
Because I initially thought that, based upon my experience, and I even have records of all of my voting history from 2005 to 2025, the most recent election. And so I can verify my occupancy at the residence.
Sure.
I know you don't have to live in the house, in the property, to vote in the county in which you still have ownership. But I have enough documentation to show that there hasn't been any breaks in my residency at the property.
okay. Well, that curiously, but it still answers. I think if we can agree that you can speak with one of the staff members about the appropriate process for your mother to officially cancel her registration, that would solve a third issue.
Okay.
And thank you so much for appearing to explain the situation.
Yeah.
Madam Chair, am I able to ask follow-up questions of Mr. Holloman?
Mr. Holman, please come back up. Thank you.
Okay. So,
And I'm gonna,
no, I meant really quickly, you mentioned the date.
hold on.
Yeah.
I'm sorry.
Uh-huh.
Madam Smith, you mentioned the date of August 5th, showing that Margaret Parker was in active status.
Yes, I
How
have,
was that determined?
and I want to also say that there are two Smiths in the department, and I believe you must have spoken with Holly Smith, who is the registration manager.
Okay.
So it is my understanding, and I just asked for a copy of the registration application that was submitted, that Margaret Graham Parker submitted a registration or a DDS application. So that was the date that we received, and that's how we process registrations.
And
That's
that was
one
a
way.
quick- I'm sorry, I cut you off.
Yeah, no, that's, so
I think this is the right, because Mr. Holloman, great counselor, but he's not, he doesn't represent the county. So if you have any questions about what happened, or you should ask the office now. This
Yeah,
would be
no
right.
question. I just wanted to follow up and provide additional information on the statement that you made, because I asked him a question on a previous conversation. How was her name connected to my address? The date of August 5th is the day before her birthday. So the vehicle that I mentioned that I own, she re-registered the vehicle in her name with my address.
So probably motor
But does she
voter.
have a Georgia driver's license?
Yes, she currently still.
Okay, well then she's a resident of Georgia, so that's why.
Yeah.
Right.
Okay, thank you.
And that was the question,
Yeah.
was the DMV issue because her birthday is August 6th, and she.
No, I understand. She's a Georgia she has a Georgia driver's license, right?
Yes.
So,
Yeah.
so I think the best practice here is that your mother, who is the elector, and I respect that you know her intent, but the voter knows their intent the best, would actually cancel the registration. So if you can just stay here for about 5 minutes afterwards, we will ensure that you talk to the right person in the office to get that information to your mother to remove her.
Okay, no problem, because the conversation she had with the agent from DeKalb was that she didn't have to change the registration or the license, but she needed to make sure that if she had no intent of voting.
I understand. Unfortunately, because she spoke with someone at DeKalb, I think there's some telephone happening. But what's important, you've answered an important question here.
Okay.
Your mother has a Georgia driver's license.
Yeah. Yeah, and now
And so-
where she is in the process of.
No problem. We got it. We got it. So 5 minutes.
Okay.
Just hang out.
Okay.
We will make sure that we get someone to talk to you. Thank you so much.
I have one
Thank you.
question for him.
Yes. Oh, we're gonna go right back around. I did not mean to. So, Miss Lee.
Yeah, it's pretty quick. You've answered everything that I had written down, so.
Okay.
Except for one, and this is just for the record. Do you have any malice towards your mother that you would want to harm her?
I'm sorry, I couldn't hear that clearly.
Do you have malice toward your mother where you would want to harm her? Was the question.
No.
No, okay.
All right.
Thank you.
Thank
What would give you that indication?
None at all.
We just want to protect,
So-
protect her interests.
Oh, no, that's why I'm here to protect her interests.
Okay.
All right, yeah.
Mr. Bowden.
I have no questions. That's a very tough gentleman to go on after. He was very prepared to speak with us today.
Mr. Abaraman.
Perhaps a question for both Mr. Parker and Mr. Holloman. Why hasn't, y'all have put so much work into this. Why haven't you gotten Ms. Parker, who you're in touch with, to contact the department and cancel her registration already?
Well, in my perspective, only speaking from my perspective, I believe that it's an issue in regards to the mailing, timing of the mailing. Because like I stated, I have everything here and the dates by which they were mailed and I received them.
Okay.
And I received as recent as last week, because actually this hearing was scheduled for last week. And now it's this week. So the mailing timing perhaps may be an issue. But because she actually lives in Alabama, I communicate all communication I get from her. Hey, you have this, do I have the right to open it and tell you what it is? Because it's headed to what she previously is aware of. Sure, and I read it to her. But when it comes to something perhaps that provides completion of a form that requires a signature, no, she hasn't completed that yet. Now, in the process by which I can get that to her, I can do that. We'll talk about that later.
Thank you.
But I can get that and that wouldn't be a problem.
Absolutely. Thank you. Questions more for Mr. Holloman. Your challenge voter, you have an investigator, so they should have found potentially a Georgia driver's license. At this point, because you spoke to you are in touch with the actual voter, was there any effort to ask her to remove herself from the voter roll?
So you're asking a question of strategy and tactic, and our position is this board has been uniquely vested the power to strike voters from the voter rolls in DeKalb County.
Okay,
And
so the
we
answer
come
is
to
no.
you- So if we come to you with that petition,
Okay, so the answer is no. You did not ask the voter that you actually have an ability to communicate with to remove themselves from the roll. Just yes or no.
that's that process for our position.
Simple
You
question.
understand?
Did you or anyone at your firm ask the
I've
voter
been in
to
contact
remove
with only
themselves?
Mr. Parker.
Okay, great, thank you. Okay, we're gonna go back around, and I'm just going this way because, so, Mr. Abaraman.
Mr. Alvarado.
So look, 6 voters, 2 aren't on the rolls anymore.
Yep.
Cheer, right? 4 left.
Yes.
Sounds like 1 by all indications, is going to be ready to contact the department and say that.
So
I absolutely understand your yes. You would rather us just sustain this challenge. She doesn't have to do anything. I get it. I get it.
It's a difficult thing to ask people to call the DeKalb County office and go through a process that
Mr.
that
Hall,
they have not done yet for an issue that is not related to anything that they're dealing with. I have 179 DeKalb County voters, and that's who I'm working for.
can I, but Mr. Holloman, two people on your list, before you even challenge them, remove themselves from the rolls. So
Do you think the
I
timing was
agree
coincidental? Do you
with-
think the timing was coincidental for that?
not my question. That wasn't the question. Okay, the last thing is,
But that was your question. Your question was, why didn't you do it? And
we're going to ask that Mr. Parker sit after, because we do have a registration and a signature, so that's fine. Your mother can remove herself from the roll, and there's a process for that. we're gonna go back around, and then I think at this point, we're ready to make a decision. Okay, Mr. Abaraman.
I'm really curious about your statements on the NBRA, and I would love our attorneys to weigh in on that. I'm going to read directly from it.
Please.
So language directly from the NBRA. Removal of names from voting rolls. A state shall not remove the name of a registrant from the official list of eligible voters in elections for federal office on the ground that the registrant has changed residence, unless the registrant, A, confirms in writing that the registrant has changed residence to a place outside the registrar's jurisdiction in which the registrant is registered, or B, 1, has failed to respond to a notice described earlier, and has not voted or appeared to vote for a certain period of time. I think that's the NGE period. Are you aware of this language?
Yes.
Okay, because there was something you said earlier about how NVRA doesn't have to do with people being eligible based on residence,
address,
right?
yeah.
Changing residence.
Yeah.
So
our legal position
yeah.
is that changing residency is very distinct from a change of address. And so what we believe we have presented is evidence that these individuals no longer have Georgia residency. That's the evidence we've tried to present. And I recognize whatever it is, that's the evidence we've tried to present.
That's right. You stand by that even though the language says a state shall not remove the name of a registrant from the official list of eligible voters in elections for federal office on the ground that the registrant has changed residence unless blah, blah. You still stand by that?
So that's a great question. Let me clarify.
Yeah.
Our position is that these changes of residency deprive this county of the jurisdiction that it would, or of the right, let me actually get my words right. Our position is that these changes and the evidence that we've presented shows that these individuals, these are not purges as maybe contemplated by the statute. Our position is that this change in residency is governed by state law in a way that doesn't preempt that the NVRA does not preempt, because these individuals are no longer residents of Georgia or DeKalb County.
Okay, I hear you. I don't think I read it that way, but I appreciate that. There's one last thing I wanted to ask you about. Are you aware of how many Georgia voters were removed from the voter rolls based on the last process governed by the NVRA after they had been inactive for a period that included at least 2 general elections?
I'm not aware of the total number of voters.
Got it. The number is 470,000 in accordance with my understanding. Do you have some understanding of why somebody might reasonably believe that that process to remove 470,000 voters should govern changes of residence? We may put ourselves or leave ourselves open for people to bring challenges 6 at a time around the state until they get to 470,000 during this period of inactive, no general election voting.
Right.
So you get why somebody could reasonably want to stick with that process instead of entertaining this idea that during that period, people could just bring challenges, even one at a time,
Right.
to present the kind of evidence that's going to exist for these 470,000 voters.
I understand the political quandary, the resource quandary.
The resource quandary,
Yeah,
right?
the resource quandary. I empathize and I agree. And again, my request is that this board focus on these challenges.
Yes, I absolutely understand
But I understand,
that.
I absolutely understand
Yeah.
the resource challenge that you're referencing. And what I would say is, when you face those challenges, I think you should consider that challenge and that difficulty at that time.
Absolutely, thank you.
Yeah.
Mr. Bowden?
And no further questions.
Ms. Lee?
I just want to say I really sympathize with you because I've been in that spot making challenges for people who have moved. In fact, they told the post office they were moving permanently to an address in Florida, and then they registered to vote at that address in Florida. And I must tell you, the challenges were denied. And I wasn't happy about that. So amongst other complaints, I took to the state election board. And they heard the case of the moved individuals in July. And they came to the conclusion that the NBRA ruled because there was no wet signature from the individual elector. And so I sympathize greatly. However, I do have a question for the executive director. When you send out the letters to the challenged electors, you enclose instructions with that. Those instructions, have they changed in the last several years?
No.
Okay. They do say that if they do not respond, that the challenges will be dropped, does it not? If it involves a change of address.
Could you repeat that?
Those instructions, which I read a lot, tell the person if it involves a change of address and they don't respond to the challenge, that the challenge will be dropped or denied.
Does our letter say that?
No.
Oh, I don't know. I don't know that I'm understanding. Is she saying that?
Your mic isn't on. Are you? Yeah, your mic isn't on.
I don't think I'm understanding the question. Maybe I
Okay.
miss.
The instructions that you enclose with those challenge letters tells the person if the challenge is based on a change of address, and you can probably get a copy, that if they do not respond, the challenge will be denied.
Holly, can you confirm that that's what the letter and instructions say?
Are you referring to the non-challenge or which instructions are you referring to?
The instructions that come with the letter to the challenged person.
Are you referring to the letter that goes to the challenger?
No.
The challenged voter, Holly?
She's referring to the instructions that we include with the letter that goes to the challenge elector?
Yes.
Well, I understand the challenges the instructions are the same for both of them anyway, the challenger and the challenged.
Okay. Is this something we can get to you?
Yeah.
Did you have any more questions while they're figuring that out? Or do you?
No, but it
Okay.
would explain why someone doesn't respond.
We'll find out what the challenge. Okay, Ms. Lohman.
Okay, thank you. Mr. Holloman?
Yes, ma'am.
Hi.
Hi.
So I had some questions. I feel like they've perhaps are not necessary now. So I think what I'd like to clarify
Yes, Ms. Loman.
is why I think my colleague, Mr. Abaraman, was going in this direction as well. What the issue is before us. And so I also want to be clear that I am not, can't speak for my colleagues, but I believe that none of us are questioning your motives. And I thank you for being transparent about the reason why you are involved.
Absolutely.
And how it came to be. So that's not what this is about.
Understand.
And you indicated that we have been, vested with this particular authority. Excuse me. That authority is extremely narrow.
Right.
And it is governed by a number of sets of laws.
I understand.
And I think that based on the interpretation and feedback that we receive from our attorneys, as well as reading, Mr. Abaraman just read into the record the specific part of the Voter Registration Act that addresses what you're asking of us, that it is beyond our authority. I do not think that your motives in doing this are bad or questionable, but I still do not think that that gives us the authority to ignore the very specific guidelines that are in the National Voter Registration Act in order to meet the needs of residents of DeKalb that we also care about. Because our duty is to protect the right to vote and access to vote of everybody, not necessarily to further an annexation process. So, and this is just generally providing context. So the NVRA, I believe, prohibits us from supporting these challenges. Additionally, there are questions that come up, and this is where I was going to get to, but I don't feel like it's necessary to go through all of this, about how we, as board members sitting in these seats, can verify the authenticity of evidence provided to us, and we don't know the provenance of that evidence. I'm sure you're a very trustworthy person. I think
Mr. Parker.
Right,
came
and
up here
we've dealt with his particular situation. We're going to get that handled. But just broadly speaking, we cannot confirm the authenticity or provenance of the evidence that any challenger provides to us.
So I will say you all have subpoena power.
Well, that's not something
You were
that is
expressly
in
granted subpoena power by the statute.
Yeah, that's not something that's in the purview of this particular hearing.
You can take it right now.
Well, I already stated the National Voter Registration Act. So I would not be voting in favor of us issuing a subpoena.
So I'll ask if you have questions about the veracity of anything that we've stated. If you are willing, you don't have to vote tonight.
Mr. Holloman,
That's not,
that's not. I'm going to ask you is there a question here? Because you should
Yes.
be responding to questions if they come up. Thank you.
I would like to simply finish this statement by saying that authenticity of evidence, being able to verify the identity of the challenged elector, just because there's somebody named Jose Montañez that's registered to vote in Hope Mills that I lived right next door to for a full year in Cumberland County, North Carolina. And there are any number of people who could conceivably be named Jose Montañez or Toops. I don't know, maybe
Mark
Toops is like Smith in Louisiana, right? We already confused our two Smiths. So there's no way for us to be able to confirm that the identity of these individuals is the identity of the same individuals who no longer live at these residences. And then finally, I would just say to the point that Mr. Abderrahman made around the intent of the voter. And we did have a very similar situation to this previously for somebody who was in the military, and their address changes when they have to move, obviously, but that does not mean that they no longer are a legal resident who intends to maintain their right to vote here. So I just wanted to say that because I was going to take you through the questions, but I don't think that that's the best use of our time here, and I am ready to make a motion if we're ready to hear one.
Thank you, Ms. London.
I have no additional questions. Okay, so can we get a motion?
Can I, just a request here, that we take this in at least 2 different batches. One applying to the folks who are already removed.
Well,
And then,
I actually don't think, if they're already moved, we don't actually need to do anything related to the 2 people that requested on their own to be removed.
so we don't have to quote unquote dismiss the voter challenge for those 2.
Do we need to dismiss? We can do it that way, yep.
Can I make a quick motion here? Motion to dismiss the voter challenges filed against Alyssa Falconer and Christopher Mann.
Second.
Okay, all in favor? Aye. All right. Okay,
Madam Chair,
yes.
Mr. Abderrahman, I think your minutes should reflect that dismissal was on the basis of those being moot.
So,
Accept that.
so the motion should reflect that this dismissal is based on the challenges being moot,
Yeah,
right?
makes sense. Perhaps I would request for the remaining 4 that Ms. Parker be, okay, great.
So is there a motion?
So I guess I'll take Ms. Parker first, and I would like to move that we dismiss the challenge against Ms. Parker.
Second?
Okay, all in favor? Aye.
Aye.
All opposed? Was that unanimous? Okay. Mr. Parker, you're gonna, can Ms. Smith, Holly Smith, raise your hand in the back? That's who you're gonna see after the meeting.
Yes, we made contact. I confirmed that I already have.
Lovely, thank you. All right. We need a motion.
Can I ask a quick question, Mr.
Yes.
How close are you now to 60%, given that 3 people are gone?
Look, my request would be that you make your decision based on the evidence that we've.
No, I totally get it.
And so that's
I
my
just asked a
position.
question, that's all. Okay, thank you.
Yeah, that's my position.
Okay, so for the remaining 2, I move that we dismiss the voter challenges against Mark Toops and Ronald Van Leeks.
Second.
Remaining 3.
It's just 2.
Oh, Montañez?
They're 3.
Oh, sorry, yes, you're right. Jose Montañez, Mark Toops, and Ronald Van Leeks. Thank you.
Second.
Personal, can we repeat the motion?
Yes. I move that we dismiss the challenges against Jose Montañez, Mark Toops, and Ronald Van Leeks.
Second.
Okay, all in favor?
Aye.
Aye. Okay, any opposed? All right. All right. Thank you. So at this time, those have been dismissed, the challenges in question. Thank you
Parker?
so much.
Parker,
Yes,
you've dismissed that as well.
we dismissed it separately because that's gonna be removed. So you'll have 3 removed, you only have 3 left. Thank you so much for your time. Okay, so that leads us into board comments. It's late on a Monday. This is our 14th meeting this month, so I don't have any comments, but I'm gonna go to my left. Mr. Abderrahman.
Is board spelled B-O-R-E-D or B-O-R-E?
That was a good one.
I do have a very strong comment that I hope people pay attention to here. This has to do with the challenge to Ms. Parker and the evidence that came out there. Georgians, don't tell one agency that your residence is one place if it's not, for any purpose. That complicates things, right? You may just feel like you get an email about renewing your license and you just want to click some buttons and have it done. You're telling DDS that that's your residence at that moment. Don't do it. We need more people to know that. You can't have multiple residences claimed to the government. And I think we can all work together in a nonpartisan/bipartisan way to make sure that Georgians know that. Don't tell DDS under any circumstances that your residence is one place, if it's not. I appreciate the effort that the Bondurant firm, Mr. Holloman, and the others are making here. I totally understand it. It's been interesting to learn about all of this, and the motive for the challenge was an open question for me. I was flabbergasted when I first saw the challenge, and now I understand it. I take this seriously. I don't think the evidence was enough for my vote to sustain these challenges, and I hope that I've fully explained why here. I'm happy to talk even more after the meeting as necessary. Thank you.
Mr. Brown, can I make one? I'm sorry, I said no comments, but there was one change to early voting that not change, but I just want to clarify. In the last meeting, we asked the board to find 2 locations in the Stonecrest areas. I just want to be clear that Stonecrest Library and Salem Panola Library will be early vote locations, but the Stonecrest Library does not have early voting on Saturday. So just want that for the record. Make sure we get that out in public, put to the public. Okay. I hope that was okay. It was administrative.
It was fine. That's what we're here for. No, and I definitely appreciate everyone for coming out tonight. I want to wish everybody a happy Thanksgiving for those who observe Thanksgiving. And obviously, I appreciate the efforts of Mr. Holloman coming in and sharing this information with us, and for his forbearance and me being granular and asking my questions as well. I want to thank everybody for their continued dedication by coming to these meetings towards election security and election integrity. And I'm looking forward to seeing you at the next meeting. Thank you so much.
Lee.
I just want to thank Mr. Holman and Mr. Parker for coming. I just sympathize with Mr. Holloman because I felt the frustration myself when I've been up there. But that's all.
Couple things. One, thank you to the department for following up and getting that second early voting location in Stonecrest in the district where the runoff is taking place. And I genuinely hope that the residents of District 5 Stonecrest will take advantage of that and participate in their municipal elections. I simply wanted to put on the record, there were some comments made during public comment that asserted that certain individuals were illegally registered. And I take great exception to that characterization. It is inaccurate, and it unfairly and wrongly impugns the character of those individuals. It is very likely an administrative matter, but that does not make it illegal. And so I just wanted to make very clear that we need to be careful about the language that we're using in these circumstances. It can be determined whether or not those addresses are proper and should be used, but that does not mean that they are illegally registered or they do not have the right to vote. So that's it. Thank you.
Okay, I think we're ready for a motion to adjourn.
So moved.
Can I get a second?
Second, third,
all in favor? Aye. Thank you all.